And Captain Reifschneider, we are live. You can start.
Hello, I'm Acting Captain James Reifschneider with the Palo Alto Police Department. Welcome to the second of 4 community briefings that we'll be providing in the coming weeks. Our goal is to provide you, the community, with information about several key areas of how we do business here at the Palo Alto Police Department. So the topic of today's conversation or briefing is use of force and use of force investigations. But before we get going, just a quick note. Public comments are enabled during this meeting, but we will not be answering questions live because the goal of these community briefings is to deliver a presentation and provide specific information on a specific topic that's consistent with what's provided in both our basic and our advanced citizens academies. Instead, any comments or questions from today's presentation will be used to inform further discussions that will happen over the next couple of months with the Human Relations Commission and other events that have not been finalized. Bear with me. So the first thing we need to talk about is where we're going with today's presentation, and that is an overview of use of force and use of force investigation. We'll cover a variety of topics, the first of which is the law and policy that's applicable to use of force and governs our use of force here at the Palo Alto Police Department. The second thing we'll talk about is officer training and the areas of training that officers receive and the volume of training they receive in a variety of disciplines related to use of force. We'll also talk about the various use of force options that are available to our officers. We'll provide you with some statistical information over a 5-year period about the frequency and type of use of force that we use here in Palo Alto. And lastly, we'll talk about reporting and administrative review, as well as touch on just a little bit the independent oversight that exists when it comes to our use of force. So the cornerstone item we'll talk about is what law and policy is applicable when we use force as a police officer. And we have to start at the top with the United States Constitution and federal law. So we'll start first with the 4th Amendment to the United States Constitution that provides that the right of people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. So the reason that's relevant to our analysis today about use of force is that, believe it or not, when police officers use force, that's considered a seizure for purposes of the 4th Amendment. So there's one key Supreme Court decision that really dictates how police use force and, more importantly, how we judge the reasonableness of that force. You'll remember that the 4th Amendment referred to unreasonable searches and seizures. So therefore, reasonable searches and seizures are permissible. So in 1989, the U.S. Supreme Court in Graham versus Connor established a 3-pronged test for determining when a use of force is in fact reasonable. Those 3 prongs were the severity of the crime, the immediate threat to the safety of officers and the public, and the active resistance on the part of the suspect. In applying this test, the court said we should look to the totality of the circumstances perceptible and available to the officers at the time of the incident. And they specifically cautioned that officers' conduct should not be evaluated using what they called 20/20 hindsight, or using information that was not known to the officers at the time of the incident. One particular observation that the court made at the time that I think is just as true now as it was in 1989 is, quote, officers are often forced to make split-second judgments in circumstances that are tense, uncertain, and rapidly evolving about the amount of force that is necessary in a particular situation. So now that we've discussed federal law, the next item for us to discuss is California law and how that impacts us. Now, the place we need to go in California statutory law to figure out what use of force is permissible and under what circumstances is Penal Code, Section 835A. So Penal Code 835A answers the question, when may force be used by a police officer? And it says, any peace officer who has reasonable cause to believe that the person to be arrested has committed a public offense, meaning a crime, may use objectively reasonable force to do one of 3 things: to effect the arrest of the suspect, to prevent the escape of the suspect, and to overcome the resistance of the suspect. So 835A goes on to further provide instructions about when a police officer can use deadly force under what specific circumstances. So let me read it to you first off, or let's go over it together. So a peace officer is justified in using deadly force upon another person only when the officer reasonably believes, based on the totality of the circumstances, that such force is necessary. And they can only use deadly force in these two circumstances. One is to defend against an imminent threat of death or serious bodily injury to themselves or someone else. The second is to apprehend a fleeing person for any felony that threatened or resulted in death or serious bodily injury, if the officer reasonably believes that the person will cause death or serious bodily injury to another unless immediately apprehended. So the first of those two things there is pretty straightforward. A police officer can use deadly force when they're faced with an imminent threat of death or serious bodily injury, either to the officer or to a member of the public. That one's pretty straightforward. The second one is a little more complex, so let's spend a little bit of time unpacking the pieces of it. So first, they can use force, deadly force that is, to apprehend a fleeing person, but not just any fleeing person, a fleeing person who's committed a felony. And so when we say felony, we're talking about obviously a more significant crime than, say, a misdemeanor. But not just any fleeing felon, a fleeing felon whose crime was a threat or resulted in death or serious bodily injury to someone. And even not just a fleeing violent felon. The police officer needs to be able to articulate that they need to use deadly force to stop that fleeing violent felon, specifically because the officer believes that if not immediately apprehended, that fleeing violent felon will commit additional violence, additional death or serious bodily injury to someone. So it's a pretty high standard. So the second admonition, or an important admonition we should note that's in the same section of 835A, is a direction to officers that an officer shall not use deadly force against a person based only upon the danger that person poses to themselves. So what that's talking about is, for example, officers are often dispatched to deal with people who are despondent or reported to be suicidal. If an officer were to encounter someone under those circumstances who is armed with a knife, well, a knife is certainly capable of causing great bodily injury or even death. However, if the person, the suicidal person they're dealing with, is only threatening to harm themselves, then obviously the officer would not be justified in using deadly force to stop that person from harming themselves. So one item we should note here before we move on from this section of 835A is the fact that it again refers in California law to the totality of the circumstances. And you'll recall from a few slides ago that that was the language that the Graham versus Connor court provided to us about how to judge whether force is reasonable. So the next thing we're going to talk about is a couple of little amendments, and I shouldn't say little, but a couple of additions that were made to the California Penal Code that went into effect January 1st of 2020. So of note, the legislature added both through an Assembly Bill 392 and a Senate Bill 230, two amendments to the Penal Code. The first was to clarify that the legislature's intent is that deadly force by police officers only be used when necessary in defense of human life. The second item that they added via these amendments was language that officers shall use other available resources and techniques if reasonably safe and feasible. So this second item here is an allusion to de-escalation. And you may be familiar with that term, and we'll talk about it more. But Californian law now provides for the most robust de-escalation training for police officers in the nation, not to mention the fact that we now require in our penal code that officers use de-escalation techniques if it's safe and feasible to do that. So having covered federal law and having covered the applicable state law, the next thing we need to talk about, the next layer of this, is Palo Alto Police Department policy. And you'll note before I dive too far in that Palo Alto Police Department policy mimics very closely the language that we saw in Penal Code Section 835, and that's for a reason. California law has very clear direction when it relates to use of force, and so we actually, for the most part, are simply implementing in our policy what's already statutorily codified by California law. So where you go to find in our policy manual direction on police use of force is in policy section 300 and those that follow. Those sections begin with a couple of what I'd like to call guiding principles. The first is that officers shall use only that amount of force that reasonably appears necessary, given the facts and totality of the circumstances, there's that term again, known or perceived by the officer at the time of the event to accomplish a legitimate law enforcement purpose. So that language there, as you'll note from the parenthetical reference, is directly from Penal Code Section 835. Force has to be reasonable and it appears to and apparently necessary given the facts of the case, and officers can only use the amount of force that's necessary. So there's some degree of proportionality expected. The second principle that is in our policy is while there's no specific way to identify the exact amount or type of reasonable force to be applied to every or any given situation, every member of this department is expected to use the guidelines in our policy to make such decisions in a professional, impartial, and reasonable manner. You'll note that this policy, as I pointed out, borrows language both from Graham versus Connor and from the Penal Code. So the next section we're going to talk about that I just made a reference to a moment ago is a subsection specifically dealing with de-escalation. It reads, officers should consider, as time and circumstances reasonably permit, conflict resolution and de-escalation techniques when responding to all types of calls for service and when engaging in self-initiated activity. So de-escalation has really always been a part of Palo Alto PD's training, certainly during my 16 years here. And it's long been a part of our policy as it related to responses to people in crisis and mental illness or mental health related calls. But I want to point out that just within the last month, we created this standalone de-escalation section within our use of force policy. Why did we do that? Well, we did that because we wanted to emphasize that while de-escalation techniques can be particularly helpful when dealing with people that are in crisis or suffering from mental health issues, these techniques can really be helpful in any type of call for service. So as you see there, we're no longer just suggesting or just requiring that officers consider these techniques in certain calls. We're telling our officers every call for service may lend itself to de-escalation techniques. So please give them some thought. So let's answer the question in our policy, when may force be used? A peace officer may use objectively reasonable force to effect an arrest, to prevent an escape, or to overcome resistance. Again, you'll recognize these three circumstances from Penal Code Section 835A. So when we decide whether a particular use of force was reasonable, we have those Graham versus Connor prongs. But as you noted, they're pretty general. The severity of the crime, the danger to the public or the officer, the ongoing resistance of the suspect. Those are helpful and those are factors we should use, but our policy actually expounds upon those and adds quite a few additional factors that supervisors should consider when evaluating a use of force. And I'm going to go over those with you right now. So some of them you'll recognize as duplicative or at least inclusive of Graham versus Connor, some of them much more specific. So we should consider the apparent immediacy and severity of the threat. In other words, is the suspect right on top of the officer, or is the officer quite a distance away and has other options available? The conduct of the individual being confronted, how violent are they? How agitated are they? How predictable are they? Are they able to be reasoned with? Officer subject factors. And what we mean by that is what might be necessary for an officer who's 5'2" might not be necessary for an officer who's 6'2". And likewise, the type of force required to detain someone who's 5'2" might be quite a bit less than the force that's necessary to detain a suspect who's 6'2". So we have to look to those things. Also age, weight, etc., all kinds of different things. We have to look at the conduct of the involved officer. And that's because the California Penal Code says that the conduct of a police officer leading up to the use of force is supposed to be considered in determining whether the force was reasonable. We have to look at the effects of drugs or alcohol. This goes to a couple of factors. One, it colors whether the suspect is actually able to effectively perceive and comply with the demands we're making. Maybe we need to take extra time to try to talk and communicate with this person or communicate in a different way. Or it may be the fact that no matter what we do with this person, because of their altered mental state, they won't be able to be de-escalated and we will have to use some degree of force to take them into custody. The individual's apparent ability to understand and comply. So I touched on that with alcohol and drugs, but it could just as easily be the case if someone is suffering from psychosis or some other mental health issue that causes them to have difficulty communicating or perceiving what we're talking about. Or for that matter, it could be someone who's deaf or someone who can't see and is having problems complying with our directions or perceiving our directions that way. So we want to consider the proximity of weapons or other dangerous items. Obviously, someone who has a gun, a knife, a bat within close reach is much more dangerous than someone who does not. We want to look at the fact, the degree to which the subject has been restrained or has the ability to continue to be restrained. What we're talking about there is clearly once we get handcuffs on someone, they're substantially less dangerous, and hopefully we won't have to continue to use any force whatsoever to restrain them. However, any seasoned police officer has encountered folks that no matter handcuffs or not, the person is going to continue to violently resist. So if that's the case, you may need to continue to use some degree of force. We want to consider the availability of other reasonable and feasible options and their possible effectiveness. So if the officer has other tools or other techniques available to them, they should be considering them. However, given the environment they're operating in or time constraints, they may not be able to use those options. Lastly, we want to look at the training and experience of the officer, the potential for injury to the officer or the suspect. We want to look at the likelihood of escape if the suspect is not captured. And moreover, we want to look at how dangerous it would be to the community if the suspect were to escape. So the last thing we're going to move on to, or I guess the next most serious thing we'll move on to, is specifically when may deadly force be used. So Palo Alto PD's policy also includes guidance on the use of deadly force, which is borrowed directly from Penal Code Section 835A. It provides the same admonition regarding the use of deadly force against someone who is a threat only to him or herself. So you'll note in short that Palo Alto PD's policy, like state law, says that deadly force is only justified in two circumstances: to protect the officer or the public from an imminent threat of death or serious bodily injury, or to apprehend that fleeing violent felon we talked about earlier that the officer believes represents a continuing threat to the public if they are not immediately captured. So the duty to intercede has been a topic of much discussion recently, so let's demystify that. So ultimately, this answers the question, what if an officer witnesses excessive force by a colleague? What should they do? Beyond that, what must they do? So Palo Alto PD's policy manual clearly states that any officer present and observing another officer using force that is clearly beyond that which is objectively reasonable under the circumstances is obligated to do two things. They're obligated to intercede to prevent the use of unreasonable force. In other words, they're obligated to try to physically intervene and stop what they believe to be unreasonable. The second thing that officer's obligated to do is promptly report these observations to a supervisor. Now, I'll point out that recently we improved our policy to make clear that officers are required to report any unreasonable force that they witness to a supervisor. Our policy always required our officers to intervene, but previously our policy could have been read as encouraging officers to report it, but not requiring them to report it. We wanted to close that loop and make it abundantly clear that we expect our officers, if they see excessive force, not only to intervene, but we expect them to report that to a supervisor so it can be looked into further after the fact. So shooting at moving vehicles, another hot topic recently. So shooting at vehicles is a very unique set of challenges. As a result, it has its own subsection within our use of force policy. Our use of force policy allows that an officer should only discharge a firearm at a moving vehicle or its occupants when the officer reasonably believes there are no other reasonable means available to avert the threat of the vehicle, or if deadly force other than the vehicle is directed at the officer or others. Officers should move out of the path of an approaching vehicle instead of discharging their firearm, if possible. Officers should not shoot at any part of a vehicle in an attempt to disable the vehicle. And it adds a very interesting admonition: shots fired at or from a moving vehicle are rarely effective, which is true. It is very difficult to hit a moving target in general. It's very difficult to hit a moving target that's inside of a vehicle. So this is not a technique that is taught as a go-to technique, far from it. In fact, it's taught as a last-ditch resort. So let's break down, though, the two circumstances that our policy complies so you understand what is allowed and what is not. So the first situation is where the vehicle itself is being used as a weapon. Picture a vehicle traveling straight at the officer, and the officer has no opportunity to get out of the way. The only way they have available to defend themselves and possibly stop that vehicle from striking and killing them is to try to disable the driver by shooting the driver. Or picture a vehicle being deliberately driven into a crowded festival or perhaps a group of outdoor diners in our closed downtown on University Avenue. The officer sees this, has no opportunity to stop that vehicle short of disabling the driver. In this case, if the officer truly has no other reasonable means available, they can shoot to stop that threat and prevent the loss of life. But you'll note, of course, the caveat I pointed out earlier, that our policy cautions officers to move out of the path of any approaching vehicle instead of discharging their firearm if that's possible. Now, the second circumstance is a little bit different. The second circumstance is where the car is not a threat itself, but someone inside the car is. So picture someone firing a gun or using some other sort of weapon from within a moving car. Here too, if no other reasonable means exist, an officer can shoot at the occupants of the vehicle to stop that threat. For those that are curious, Palo Alto PD has not shot at a moving vehicle in 20 years or more. So as important as the guidelines that we provide to our officers about when force can be used and what type of force can be used are the rules we provide to our officers about what to do after force is used. So our policy has some requirements that I think are pretty important and worth talking about. So medical treatment. Prior to booking a release, medical assistance shall be obtained for any person who exhibits signs of physical distress, who has sustained visible injury, expresses a complaint of injury or continuing pain, or who is rendered unconscious. If someone exhibiting one of those symptoms is offered medical treatment and declines, our officers are expected to very thoroughly document that refusal, because our preference, of course, is to get medical treatment. The goal of any use of force is to gain control of the suspect, not to hurt the suspect. Once we've done that and gained that control, our officers must transition from that enforcement role to a role of rendering aid or summoning aid as is appropriate. So we've now gone over applicable federal law, we've now covered applicable state law, and we've covered applicable Palo Alto Police Department policy. Now let's talk about the training that our officers receive here at the Palo Alto Police Department as it relates to use of force. To do that, it's helpful to understand that police officer training, both basic academy training and ongoing training in California, is regulated by California Post, which stands for the Peace Officer Standards and Training Bureau. Agencies can provide training above and beyond what Post requires, and in many cases, Palo Alto PD does just that. But every California agency is governed by Post and has to do at least what Post requires. So for good reason, tactical communication and de-escalation is the first topic we're going to talk about. So 16 hours of de-escalation and use of force instruction is provided during the Basic Police Academy. And let's talk about that. So de-escalation is a critical topic that that officers are trained on, and it encompasses de-escalation and tactical communication both. Essentially, this is using listening, persuasion, and negotiation techniques to avoid use of force in the first place. As of 2019, all basic police academies in California, by Post regulation, began providing 16 hours of de-escalation and use of force training to every police recruit. It's noteworthy that this training on use of force and de-escalation is separate and distinct from any training the officers are receiving on arrest techniques, weapons, or any kind of physical activity. This is just about using de-escalation techniques in the context of what would otherwise be a use of force situation. So once an officer graduates from the police academy, Palo Alto PD provides 2 hours of tactical communication training to every new Palo Alto PD officer. This is above and beyond anything that Post requires. On an ongoing basis, though, Post requires that every police officer in the state of California receive at least 2 hours of tactical communications training every 24 months, and Palo Alto PD always complies or exceeds that requirement by Post on its 2-year cycle. Crisis intervention training. Many police calls for service, criminal and otherwise, involve persons with mental health issues. CIT, or crisis intervention training, is designed to prepare officers for interactions with those in crisis and those suffering from mental health issues. Much of the training in the CIT program is actually provided by mental health professionals. During the Basic Police Academy, every police recruit receives 40 hours of CIT training. Palo Alto PD provides 24 hours of additional advanced crisis intervention training to each of its new officers. Post has no requirement beyond the police academy for CIT training, but because Palo Alto PD sees the value in CIT training, we send every one of our officers to that advanced crisis course. At this point, 95% of our current officers have attended that course, and the last few are our brand new officers who will attend hopefully the next scheduled session. So defensive tactics, it's known by a couple of different names: defensive tactics, arrest control techniques. Essentially what we're talking about is the use of control holds or manual force to gain control of a suspect. During the police academy, every recruit receives 60 hours of defensive tactics training. Palo Alto PD exceeds that Post standard by providing an additional 40 hours of additional defensive tactics training by our instructors to every new officer before they ever hit the street, but after they finish the police academy. Post requires that every officer receive 4 hours of defensive tactics refresher training every 24 months. Palo Alto PD typically and pretty consistently doubles that and provides 8 hours of refresher training every 24 months. Firearms training. So firearms training involves the development of proficiency and marksmanship among police officers. During the academy, recruits receive 72 hours of firearms training per Post requirements. Following the academy, and before they ever hit the street, Palo Alto PD provides 8 additional hours of in-house firearms training to every new officer. This is administered by our in-house firearms instructors, who again work with these folks, work with our new officers on marksmanship, weapons proficiency, but also drill down with them to make sure they're familiar with applicable law and policy as it relates to use of a firearm. Post requires that every officer receive 4 hours of refresher training on firearms every 24 months. PAPD far exceeds that standard, typically providing as many as 40 hours of firearms training during that same 24-month period. Now, you may be asking why officers need so much training on firearms when we almost never use them. Well, the authority to use lethal force is something that we take very seriously, and while we hope our officers are never ever called upon to fire their weapons, if that situation arises, we want them to be prepared to do so in the safest way possible and in a way that's consistent with law and policy. That's why it's always a priority for us to maintain that level of training. So use of force options, that's the next topic for our discussion. In other words, what tools do officers have available to them when they respond to a call for service out in the field or self-initiate activity? Tactical communication. We've heard me use the term already. It's in a way synonymous with de-escalation. Tactical communication is really a key and first and really important technique that an officer has at their disposal anytime they respond to a call for service. As we teach our officers, the goal of every law enforcement contact is to generate voluntary compliance. We should be using negotiation, persuasion, and listening skills to try to generate that voluntary compliance if circumstances allow us to do that. Unfortunately, try as we may, some individuals can't be persuaded, and unfortunately, try as we may, some circumstances don't allow us the opportunity to try tactical communication, but it is our go-to tool. Manual or physical control holds. So the lowest level of force employed by an officer is physical force or manual force. It is also by far the most commonly used level of force, which you'll hear about more in just a few minutes. Typically, manual force consists of nothing more than control holds designed to control the person long enough to be safely handcuffed and detained. A special note here, Palo Alto Police Department, in collaboration with our Officers Association, recently banned the use of the carotid restraint. And for those curious, the carotid restraint had only been used here in Palo Alto one time over the last 10 years. But it was part of our prior use of force policy, and we can report now that with the support of our POA, it has been taken out. Tools. Tools are what, the term we use to describe the things officers have on their duty belt. If manual force is ineffective or impractical, officers have a variety of tools on their duty belt or in their vehicle that they can deploy. Officers carry OC spray, commonly referred to as pepper spray. It's designed to cause temporary discomfort to the suspect and potentially some blurred vision due to tears, potentially a runny nose, coughing, other things that cause distraction to the suspect. And the hope is that that distraction will give the officers an opportunity to safely put handcuffs on the suspect without inflicting any additional injury or any long-lasting injury. Our policy provides that OC spray should only be used against those engaged or about to engage in violent behavior. Our policy furthermore says that OC may not be used against people who merely fail to disperse or do not present a threat to officers or others. You'll see a theme as we go through these tools that our policy provides guidance on appropriate application and inappropriate application for most of our tools. Officers also carry a collapsible baton on their duty belt, which can be used to strike a suspect. You may have seen officers on TV with a large wooden baton. Our officers, if you've not looked at them closely, do not carry those wooden batons. Instead, they carry a collapsible baton, which can be easily stowed on their duty belt and expanded if needed for use. We train our officers with those batons only to use them in specific circumstances, and also we train them to avoid specific areas due to the risk of serious injury. Less lethal. Less lethal is an interesting category of law enforcement tool, and it refers to the category of projectile weapons that do not fire traditional bullets like a handgun or a rifle or a shotgun. They're referred to as less lethal rather than non-lethal because in theory, if deployed improperly, they could actually cause death. Every Palo Alto police vehicle is equipped with a Sage. The Sage fires essentially a large rubber round that's intended to cause temporary discomfort and a distraction, such that the suspect is distracted long enough to be safely handcuffed. An example of an appropriate use of this tool, that being the Sage, would be a stationary subject who's armed with a knife or bat and is at an adequate distance from the officers that they're not in fear of him imminently using the knife on them. It's a way to distract and potentially disarm somebody who is not moving and has something other than a firearm. Palo Alto PD policy cautions officers when using the Sage to avoid the head, neck, spine, or groin areas due to the increased risk of serious injury. One other less lethal tool I should talk about is what we call a pepper ball. It's essentially a paintball gun in appearance that fires small balls that instead of being filled with marking paint are filled with essentially OC powder. So it has largely the same effect as OC spray, but it can be fired from more of a distance. It's used in the same way to distract someone who is acting violently or potentially violently and provide a distraction long enough for them to be safely detained and placed in handcuffs. So we've talked quite a bit about our policies as they relate to firearms and about law as it relates to firearms. But as you may know, our officers also have the ability to deploy a taser. Tasers are designed to produce a brief neuromuscular disruption that incapacitates a suspect long enough to be safely handcuffed. The taser may only be used under certain circumstances. A taser, per our policy, can only be used when a subject is violent or physically resisting, or the subject has demonstrated by words or action an intention to be violent or to physically resist and reasonably appears to present the potential to actually harm officers or him or herself or others. So a taser is a serious tool, but at the same time, it's a less lethal alternative to a handgun that allows us, hopefully, to incapacitate somebody just for a matter of seconds and have our officers staged and ready to pounce in order to detain that person safely before they are able to regain their senses. So our policy provides, much like with these other tools, guidance as it relates to a taser. Officers are directed to avoid targeting the head, neck, chest, and groin areas for a variety of reasons. The probes from the taser have the potential to be sharp, and so you wouldn't want to aim for someone's face. You could, in fact, strike them in the eye. You wouldn't want to strike someone in the throat. The other areas of the face, the other areas of the body also are areas that Taser identifies as having an elevated risk of adverse side effects, so we caution our officers not to target those areas. Also, our policy identifies certain subjects or certain individuals where Taser usage is not ideal, and our officers should avoid using the Taser if possible. Those types of people are pregnant individuals, elderly individuals, obvious juveniles, individuals with obviously low body mass, and that's because of the science of the Taser, individuals who are handcuffed, individuals who've been recently sprayed with a flammable chemical agent. On that one, that's important because obviously a taser works with electricity, and although the OC spray that we use is deemed non-flammable, out of an abundance of caution because it does have some degree of pepper oil in it, we caution our officers not to use pepper spray on there for risk of it becoming inflamed. The last category of people that we don't want to use tasers against, or at least avoid tasers against if at all possible, is someone whose position or activity may result in collateral injury. So examples of that would be someone who's running. If you strike someone who is running with a taser, it's very, very likely that they're going to fall from that standing position and sustain significant injuries. Or if someone's sitting at an elevated position and they are struck with a taser, they could fall from that elevated position and sustain serious injuries that have nothing to do with the taser and everything to do with the fall. So in a perfect situation, we want to identify someone where a taser can be deployed in such a way that they can be grabbed before they hit the ground, or in such a way that they fall a short distance to the ground and are uninjured. So now that we've talked about the types of force used, let's provide a statistical background for when that force is used, how often it's used. Really, let's talk about the frequency, or perhaps better put, the infrequency with which Palo Alto police officers use force. So you'll see from the pie chart there that for the calendar years 2015 to 2019, our officers used force a total of 62 times. That's an average of approximately once per month. You'll also notice that in over 3/4 of these incidents, physical strength was the only force used. Just to break it down further, you'll see that only once was a handgun used, only once was a baton used, and 11 times a taser was used over a 5-year period. We've chosen to highlight 2015 through 2019 because it gives you a full 5-year snapshot of our use of force behaviors. So here's a few bullet points to consider. As I pointed out, 62% of our uses of force, 62 uses of force occurred over that 5-year period, and that was over 250,000 calls for service that our officers responded to. That's quite a few calls for service that our officers responded to, only 62 uses of force. So that works out to approximately 0.002%. As you can see, our officers interact with the public quite a bit, and thankfully only need to use force during a very small fraction of those encounters. Moreover, what you'll see from below is that when force is used, the vast majority of the time it consists of manual force only. In fact, 77%. We have one officer-involved shooting during this reporting period, and that happened in 2015. We have a total of 2 officer-involved shootings over the past 20 years. We have 0 instances of an officer shooting in a vehicle during this reporting period, and in fact 0 in the past 20 years. 11 taser activations, 1 application of the now unauthorized carotid restraint, and that was our first in 10 years, 1 use of a baton, and 1 use of a sage. So reporting and administrative review. So just to catch up where we are now, we've gone over applicable federal law, applicable state law, applicable Palo Alto PD policy. We've talked about the type of training that our officers receive. We've talked about the types of use of force that our officers use. We've talked about some statistics about that use of force. Now we're going to talk about how we document that force and how we investigate that force after the fact to make sure that it was within policy or not. Per Palo Alto PD policy, any use of force, including pointing a firearm at someone, even if it is not discharged, will be documented. Some minor uses of force without any injury will be documented in the associated police reports. Other, more significant uses of force and those involving an injury are documented in a separate administrative supervisor's report. But the bottom line is any use of force by our officers is properly and shall be properly documented per our policy. The policy specifies certain situations where a supervisor's report is mandatory. Those include any use of force that results in an injury, results in a complaint of pain from the suspect, or a loss of consciousness by the suspect. Also required is any use of OC spray, any application of a baton, any activation of a taser, any application of a less lethal device like pepper ball or sage, any firearms use, and any canine bite. So we have an internal review process, and that's what I'm talking about when I describe a supervisor's use of force report. They're prepared by the involved officer's immediate supervisor following a thorough investigation. Typically, this investigation involves interviews of the suspect if they're willing to provide a statement, interviews of the involved officers, a review of any associated police reports, a review of any and all associated video that we have from our cars and from our officers' body-worn cameras. We also review video from nearby businesses or individuals if it exists. So our supervisors are conducting a lengthy and detailed investigation of what happened leading up to the use of force, what happened during the use of force, and then applying those facts to our policy and applicable law, and rendering an opinion as to whether the use of force was within policy. Once that supervisor completes their use of force report, the use of force report makes its way up to each level of command here at the Palo Alto Police Department for review. If at any level additional follow-up or correction is identified, it can be sent back down for additional work and correction as necessary. Ultimately, that use of force report lands on the desk of the chief of police, who is the ultimate determiner of whether training or discipline is ordered for the involved officers. So one last item that's worth noting here, although one of our future community briefings will touch on it in more detail, is the existence of our independent police auditor. So for more than 10 years, the Palo Alto Police Department has had an independent police auditor with whom the city contracts. That police auditor is tasked with and responsible for reviewing all of our administrative investigations involving officer-involved shootings, any taser applications, and any uses of force that are the subject of a citizen complaint or the subject of an internal investigation. The IPA prepares a twice annual report where they evaluate the thoroughness and objectivity of our investigations and the appropriateness of our findings. These reports are published to the City Council and for public view on the website. They are also viewable in archive going back to 2006 on the Palo Alto Police Department's website. As I alluded to, on Wednesday, July 22nd, community briefing number 4 is on the accountability measures within Palo Alto Police Department, and that briefing will have a more detailed rundown on the independent police auditor and their specific role in auditing police operations. So we've reached the end of our use of force and use of force investigations briefing. It's my sincere hope that the information provided today has given you a better understanding of police use of force here in Palo Alto. I'd like to close by sharing a relevant portion of our use of force policy. The department recognizes and respects the value of all human life and dignity without prejudice to anyone. Vesting officers with the authority to use reasonable force and to protect the public welfare requires monitoring, evaluation, training, and a careful balancing of all interests. I think that excerpt from our policy brings together a number of the topics that I've covered today during this briefing. As a department, we recognize the gravity of using force. We provide our officers with a great deal of training, much of which is aimed at avoiding force altogether. Our commitment to you is that when we do use force, we will continue to critically examine ourselves and our policies for areas of improvement. Thank you for listening to this community briefing. If you're interested in more information, there are a variety of sources listed here where you can get information about our accountability, various other documents that we have for public review. Again, those independent police auditor reports that I alluded to earlier, full crime statistics dating back several years, as well as our 2019 annual report, of which we're very proud. Again, thank you very much for attending today's briefing, and thank you.